Missing documents, missing citizenship, what Greece's latest AIDA report teaches Europe. Welcome back to law-clinic.eu. This week, the European Council on Refugees and Exiles published the updated AIDA Country Report on Greece for 2025. At first glance, it appears to be another report about asylum policy. But if we look more carefully, we find something much broader. The report raises an important legal question that affects not only asylum seekers, but also families, children, and anyone whose legal identity depends on documents that may no longer exist or cannot be obtained. We often assume that proving who we are is simple. You present a birth certificate, a marriage certificate, a passport, and the legal system recognizes your identity, but reality is often much more complicated. The Greek report discusses situations where people cannot obtain certified civil status documents. It also refers to children whose birth registrations may not include the father's name and highlights continuing delays in naturalization procedures. These may sound like administrative issues. In reality, they are legal issues with lifelong consequences. Without reliable civil registration, proving family relationships becomes difficult. Without recognized family relationships, nationality may become uncertain. And without nationality, many fundamental rights become difficult to exercise. This is exactly why documentation should never be treated as a simple bureaucratic requirement. Documentation is the gateway to legal identity. One of the most interesting parts of this week's report is its emphasis on identifying statelessness before authorities make important legal decisions. Although this recommendation appears in the asylum context, the underlying principle is much wider. Authorities should not simply assume a person's nationality. If nationality is uncertain, disputed, or impossible to prove, the legal system has a responsibility to investigate before making decisions that depend on nationality. This principle is particularly important for children. Children cannot choose where they are born. They cannot control how different countries register their birth. They cannot correct mistakes made by public authorities, yet they often bear the consequences for years. This week's report also fits into a broader European trend. The Netherlands continues to distinguish between unknown nationality and actual statelessness, recognizing that uncertainty requires legal examination rather than administrative assumptions. Meanwhile, the Czech Republic emphasizes universal birth registration for every child, regardless of the parent's nationality, recognizing that registration is essential for healthcare, education, residence rights, and future citizenship questions. Although these countries use different legal systems, they all point toward the same conclusion. The real challenge is not simply determining who qualifies for citizenship. The challenge is ensuring that administrative systems are capable of recognizing and proving that legal status when documentation is incomplete or unavailable. In my view, this is one of the most important lessons from this week's report. Citizenship law is not only about nationality statutes. It is equally about how legal systems respond when ordinary documentation fails. A fair legal system should not leave people trapped in uncertainty simply because the documents needed to prove their identity cannot be produced, especially when children are involved. Ultimately, the purpose of the law is not to preserve uncertainty, its purpose is to resolve it. Thank you for watching. If you enjoy comparative legal analysis and discussions on citizenship, statelessness, judicial reasoning, and legal reform across different legal systems, please subscribe to the channel. And as always, you'll find the full article linked below. See you in the next video.